Did you know, in Connecticut, you can't sell a pickle and call it a pickle if it doesn't bounce? This series of statutes came around in 1948 as a result of a farmer that was selling pickles that weren't fit for human consumption. That man was then fined $500 for his imposter pickle business. Now, another legal pickle you might find yourself in Connecticut is the eviction process. An eviction process can differ from county to county, but they more or less follow the same general process. You start with sending a clear written notice, you fill out the forms, serve the tenant, attend the trial, and then you wait for judgment. And truth be told, a lot of evictions just depend on the lease signed between the tenant and the landlord. So what I'm going to do is detail out a nice little summary so you can reference this during the eviction process. And this doesn't just go for landlords. As a tenant, it's important to know your rights and responsibilities as well. And just to be clear, I'm not an attorney, I didn't go to law school. This is just a lot of information that I've conveniently gathered in one place for you to reference if you're ever in this situation. And while I plan to provide you with a comprehensive guide and timeline to help you navigate the process, if you ever find yourself in this incredibly stressful and often confusing situation, you should probably consider contacting an attorney for legal help or just to learn more about rent regulations and the eviction process in your area. So first of all, it's important to know that the landlord cannot begin to file for the eviction process without first providing a written eviction notice that is up to par with the notice requirements dictated by Connecticut law. The most common reason for an eviction is just the non-payment of rent. A landlord can evict a tenant for not paying rent on time. For tenants with a 1-week tenancy, rent is considered late in Connecticut 4 days past its due date. An example of this is that if the rent payments are due on the 20th and the tenant hasn't been able to pay the rent by the 24th, well then the payment is considered late. For other types of tenancies, rent is considered late 9 days past its due date. So for example, if rent payment is due on the 20th and the tenant has not been able to pay by the 29th, then the payment of the rent is considered late. And a grace period may be given to the tenant if it is stated within the lease. Now, before a landlord can start with an eviction action for a late payment of rent, they must give the tenant an eviction notice called a 3-day notice to quit. This informs the tenant and or the renters that they have 3 days to comply with paying the rent or vacating the premises. Now, should a tenant be unable to comply with the timely payment of rent, then the landlord can continue filing for the eviction process. The lease rental agreement terms vary from tenant to tenant, but generally it outlines the responsibilities of each party for the entire duration of the tenant's stay. Both parties must uphold the terms of the lease at all times. A tenant committing lease violations might find themselves facing an eviction, but before a landlord can start evicting a tenant, they must provide a 15-day notice to quit/comply. So basically, this gives the tenant 15 days to resolve their problems or leave the premises. Lease violations in a Connecticut eviction could include, but are not limited to, damage to the rental unit, smoking in non-smoking areas, housing a pet in a pet-free rental unit, or failing to comply with material and health safety codes. Examples of a material health/safety code violation include not throwing out the trash for long periods of time, inviting bugs and or rodents into your unit, damaging the electrical wiring of a unit, or ruining the plumbing fixtures of a unit. Now, should the tenant be unable to resolve the violation within the notice period, then the landlord may continue filing for an eviction lawsuit. In Connecticut, a tenant who has engaged in illegal activity on the rental premises can be tried in an eviction lawsuit. The landlord has to give the tenant a 15-day notice to quit before filing for the eviction lawsuit. Examples of illegal activity include, but are not limited to, theft, violence, or assault, being a serious nuisance, being involved in the creation, distribution, or consumption of a controlled substance, or threatening the physical safety of the landlord and other tenants within the rental premises. If the tenant was convicted of prostitution or illegal gaming within the rental unit, then the landlord is not legally obligated to provide a written notice. If that is not the case, the landlord may only proceed with filing an eviction lawsuit after the notice period expires. The landlord could decide to take the rental property out of the rental market. This means they no longer want to rent it out. If so, they must issue a 3-day notice to quit before filing for an eviction lawsuit. At that point, the tenants have no choice but to move out if the landlord decides to discontinue the use of the rental property. Now, should the tenant remain on the rental property after 3 days, then the landlord may continue to file for an eviction process. Now, there are cases where the landlord decides to raise the rent prices for one reason or another. If the increase in rent fees is reasonable and clearly allowed in the lease, but the tenant refuses to agree with them, well then the landlord must provide the tenant a 3-day notice to quit. Should the tenant remain in the rental property after these 3 days, then the landlord may continue to file for the eviction process against the tenant. Sometimes a buyer may take an interest in the rental property but not wish for it to be rented out, or the landlord changes their mind, decide that they want to stay in the property instead. For either case, the landlord must give the tenant a 3-day notice to quit. Should the tenant remain in the rental property after those 3 days, then the landlord may continue to file for an eviction lawsuit. A Connecticut eviction process does not allow a landlord to file an eviction case against a tenant without good cause. As long as the tenant does not violate any of the rules from the lease, they can stay until their lease term ends. However, if the tenant becomes a holdover tenant, the landlord may begin filing for eviction proceedings. A holdover tenant is somebody who overstays their lease term without applying for a renewal. A landlord can evict a tenant who stays in the property even a day after their written lease ends, assuming they haven't arranged for a lease renewal. This type of eviction only applies if the landlord does not want to renew the tenant's lease. The required notice is a 3-day notice to quit regardless of the tenant's tenancy or lease type. Now, should the tenant remain on the rental property even after their notice period ends, then the landlord may take the case to court to begin the eviction process. Now, the next step in the eviction process is filing the summary process for eviction. The landlord must wait for the notice period to pass before they can start filing. At the time of recording this, the filing fees for the state of Connecticut are $175. The steps in filing an eviction action. First, proceed to the housing court or superior court the rental property belongs to. Then, fill out the court forms and hand them over to the court clerk, ensuring all information written down is correct, and then pay the filing costs. It takes 3 to 15 days depending on the reason for eviction before a landlord can file a complaint. Now, before filing an eviction with the court, you need to issue the tenant a notice to comply. If you go to our website, you can find and download a free PDF or Word template for your eviction notice, or you can use a step-by-step wizard that'll guide you through the entire process to make sure that you're submitting the legally correct notice. The step-by-step wizard will ask you to pay a small fee at the end, but it is a small price to pay to ensure legal compliance and protection. I mean, imagine going through all of this just to find out you did the first step of the process incorrectly. It's a small price to pay for peace of mind. After filing a legal complaint, the next step in eviction cases is serving the summons and complaint to the tenant. The landlords must not serve the documents themselves. The summons and its supporting documents must contain information such as the date and time of the eviction court case. Connecticut allows the marshal, constable, or really any other officer to serve these documents. They must be delivered to the tenant at least 12 days before the eviction process proceedings are scheduled to begin. The summons and complaint must be served through one of the following methods: personal service, where the summons and complaint are served to the tenant in person, or alternative service, where a copy of the summons is left at the tenant's place of residence. There's no need to mail a copy if the official chooses this service. According to the state of Connecticut's court systems, tenants need to file an appearance with the court so that they may attend the eviction proceedings in the court. The written answer serves to inform not only the court but the landlord that the tenant is aware of the eviction process. Alongside filing for appearance, tenants must also file their answer if they wish to dispute the landlord's claims against them. They have 2 days from the date listed on the summons to file for an appearance and a written answer. Otherwise, the landlord can ask the court to make a default judgment in their favor without needing an eviction hearing. And if the tenant only filed for an appearance without a written answer, then the landlord can still motion the court for a default judgment. The tenant is also served with this motion. Should the tenant fail to respond to the complaint 3 days after the landlord files the motion for default judgment, no hearing will be held and the landlord will automatically win the case. The summons and complaint must be served at least 12 days before the court case is scheduled. Tenants must file an appearance and a written answer within 2 to 5 days. Next is asking for possession. First, you're going to file a motion to obtain judgment and then get a judgment for possession. In order to receive judgment for possession, the landlord has to provide a strong argument backed up by solid evidence against their tenants. Should the tenants fail to show up to the hearing or fail to file an appearance and a written answer, the landlord may win by default. A tenant can appeal this judgment within 5 days of the summary possession execution being issued in favor of the landlord. Next procedure if the tenant disagreed and filed an answer. Filing an answer and appearance is necessary for an eviction hearing to be held or scheduled. Should the tenant fail to file for an appearance and a written answer, the hearing is canceled and the landlord receives default judgment. However, if both parties are present, the landlord has to support their claim with evidence and show it to the judicial officer. This includes, but is not limited to, a copy of the deed and lease or rental agreement, rent receipts, rent ledgers, bank statements, witness statements, or photo and video documentation of the violations committed by the tenant. The tenant, on the other hand, may counter these allegations during the hearing and provide their own evidence against the eviction process. A hearing for an eviction action is scheduled after the tenant files for an appearance and a written answer. Once the court receives both of these, the hearing is scheduled within 7 to 10 days. A tenant can appeal the judgment within 5 days. If the landlord wins the case and gets a writ of execution, once the landlord wins the case, provided the tenant does not file for an appeal or reconsideration, the court will issue what's called a writ of execution 5 days after the landlord wins the case. The writ of execution is a court order informing the tenant that they must move out of their housing on the property or they could be forcibly evicted. According to Connecticut state law, tenants have 5 days to leave the rental unit of their own will before receiving the execution. The final step in evictions is to move the tenant out of the apartment or dwelling. Connecticut law gives tenants 24 hours to move out once they either receive the writ of execution or it is posted on the rental household unit. Now, should they remain inside the household premises even 1 day after receiving the writ, a law enforcement officer can forcibly evict them. The only exception to this is if the tenant has requested a stay of execution. The longest stay of execution can be 6 months. Now, unless the tenant was a severe nuisance, a squatter, or they weren't paying their rent, they can request a stay of execution for up to 6 months. In cases involving non-payment of rent, a tenant may be able to request a maximum of 3 months for their stay of execution. And remember, only a law enforcement officer like a state marshal can evict the tenant by force. A landlord cannot resort to a self-help eviction. Don't do it. We'll get to that later, but don't do it. So quick recap. The writ of execution is issued 5 days after the landlord wins the case. The tenant must vacate the property within 24 hours after they receive the writ unless they request a stay of execution, which could be anywhere from an extra 3 to 6 months. So all things considered, it takes on average 4 to 7 weeks to finish out the eviction process in Connecticut. Like I said, eviction hearings are scheduled out within 7 to 10 days once the tenant files an answer and the court receives it. If the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge and win your case. If you don't have good evidence, this could make or break the entire eviction request in the event of a dispute. Here's a couple ways to stay organized. 1. Keep a physical paper trail. It's nice to have everything in writing, but also keep in mind that this takes up a lot of storage space and things could get lost, damaged, or stolen. Or scan documents. Scan everything into your computer. A great scanner is the Brother ADS 1700W, and that's just under $300, or the Fujitsu SnapScan IX 1500, which is just under $600 at the time of recording this. Make backups of everything. Store and back up everything using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable. Or put it all in one place. Use a property management software to save everything from your lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, anything that you can imagine. This works especially well when you scan your documents because you can scan those documents directly into your software. If the tenant doesn't pay rent and they dispute the claim, it's important that you show the judge the following. 1. Show them your lease agreement. Show them the terms of the agreement, when rent is due, and any penalties outlined for late payment. 2. Show all previous payments, how they were normally made, and what date they were normally paid on. And show payment returns, if any checks bounced, if their bank account had insufficient funds, or they did a chargeback dispute on their card. Show it all to the judge, and show any fees that your bank may have charged you and any penalties you are owed according to your lease agreement. Show all your messages. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, it's important to show this too. While it's not usually needed, it's still good to show that they were aware of the situation and they were given time to cure by making a payment. This is why it's always best to have everything in writing instead of making phone calls or face-to-face meetings. If you're evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof, and you can do that using one of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's pretty safe to say you'll normally win this dispute. Take a video. Even if you didn't catch them in the act, the next best thing to do is record a video with your phone of any damages or lease violations. And after that, it's pictures. They say a picture is worth 1,000 words, and in this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to be seen by email or printed out. Once again, show them your lease terms. Show the court exactly which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, I'd start adding all of your potential reasons to evict somebody into your agreement. Remember that thing I brought up earlier called a self-help eviction? Well, a landlord cannot resort to a self-help eviction. Don't do it. We'll get to that later, but don't do it. What is that? A self-help eviction is pretty much a DIY eviction. Examples of this can include things like changing the locks, taking the tenant's belongings, removing the front door, or turning off the heat and electricity. Many states actually specify how much money a tenant can sue for if the landlord has tried to illegally evict the tenant through a self-help measure of some sort. Some state laws also provide for tenants' court costs and attorney fees if the tenant successfully sues the landlord and/or give the tenant the right to stay in the rental unit anyway. In almost every state in the US, it is prohibited for a landlord to forcefully eject the tenant from the property. In other words, in most states, self-help evictions are illegal. The tenant can only be removed from the rental unit after the landlord has successfully won an eviction lawsuit. And even then, the only person authorized to remove the tenant is either the sheriff or the constable. Connecticut law has made it illegal for a landlord to personally remove tenants from the rental unit. Well, according to Connecticut's Civil Code, you may be liable for tenants' court costs and attorney fees. The statute also gives the tenant the right to stay. Additionally, tenants may ask for an injunction that prohibits any further violation during the court action. So basically, no matter how bad you want to do it, just do it the right way the first time, or it can cost you a lot more than that 1 month's worth of late rent. Let's answer some FAQs. No. A landlord could actually be sued for a forceful eviction of a tenant if they skip the proper eviction processes. It is against Connecticut state law to not provide the tenant with the appropriate written notice before proceeding with an eviction action. And in the state of Connecticut, tenants can sue their landlords for double the actual damages, and tenants can also receive a refund on the attorney fees. As an added consequence, the landlord may be found guilty of a misdemeanor for even attempting this type of eviction. So don't do it. Well, a security deposit is money collected by a landlord and held in their trust until a tenant ends their lease. In the case that a tenant damages their rental unit, the landlord would then use the security deposit to pay for the repairs. However, if the tenant does not owe the landlord any money once their lease ends, the security deposit is then returned to them. Charges for a security deposit can be as little as 1 month rent or as much as 2 months rent. A landlord can only charge a tenant who is older than 62 a maximum of 1 month's rent. Honestly, look more into security deposits. You really need to understand how these deposits can help protect you as the landlord when either there's unpaid rent or unforeseen repairs. Okay, so I know that was a lot, and if you're still confused, don't worry, we have a blog post where we explain all of this and more, and I'll leave a link for that in the description. Thank you so much for watching. I hope I was able to help. Subscribe if you haven't already, and be sure to check out this video where we answer some of the most frequently asked questions that property managers get.